you. Welcome to today's webinar on privacy, data, and cyber security issues in international arbitration. This is a joint presentation of the law firm of Orrick and the Silicon Valley Arbitration and Mediation Center. My name is Jonathan Fitch. I'll be moderating today, and I will begin by introducing Les Schiefelbein, independent arbitrator and the CEO of the Silicon Valley Arbitration and Mediation Center. Les?
Oh, thank you, Jonathan, and good morning, at least from the west coast of the United States, to everyone to your location. As Jonathan said, this is a great program, and I'd like to thank Orrick in particular. James, thank you so much, and Jonathan. Jonathan is the chair of the Silicon Valley Law Firm Coordination Committee, and he has had a number of webinars this year. And I'd also like to thank the panel members we have today, Stan and Keely and Maxie and Alexander. Thank you very much. Just a brief word about Silicon Valley, because I presume everybody knows about Orrick. It is a organization which has been providing advice and content to the international ADR community for about 6 years. We are not an institution that takes cases. We merely are an advocate for alternative dispute resolution in technology matters. And we actually started in Silicon Valley, although today we have a global footprint because of the thought that companies in Silicon Valley would be better served in resolving their disputes through ADR and having the services of individuals who are knowledgeable in ADR matters and can act as neutrals. And also, due to the fact that we don't have live programming anymore, I'm very happy to say that this year, this is the 25th webinar that Silicon Valley has presented since January of this year. So thanks to the panelists, thanks for the attendees, and Jonathan, please back to you.
Well, thank you, Les. Our panel of highly esteemed practitioners are here to offer you their guidance on current topics in cybersecurity. They will also answer questions which you may submit through the Q&A feature of Zoom. I will monitor that as we go along. And we're going to begin our panel discussion with Alexander Dussartel, the General Counsel of SICPA. Alex, SICPA deals with the transmission and storage of sensitive data in Europe, the United States, and globally. That data includes highly sensitive healthcare information for some technologies. The data also extends to security features for banknotes in global circulation. So as General Counsel, what most concerns you regarding the security of the transmission and storage of that data?
Hello, Jonathan. Thanks. Hello, everyone. Well, as SICPA as a company, the vision of SICPA is enable trust. So, trust today, is very important to the economy, and the economy today is very much in the digital world, which means that there are indeed data stored in many different places. And as we're going more, we're dealing with technology. So from security ink for banknotes to now some digital solutions, we need to really carry the message of trust to our clients, who could be public authorities, governments, central banks, but as well private players. And so the protection of those data from a data protection standpoint and cybersecurity are really critical for the reputation of the company overall. So there is not one day where the team doesn't have to deal with questions around data protection and or cybersecurity, whether it's in Europe, where maybe with GDPR we can handle something, but then you go to the US, you go to Russia, China, Africa, different countries. So that's a true concern for our teams. And when we are dealing with our partners, customers, well, we need to enter into contracts. We need to decide of a forum in the event of a breach, a leak, a dispute. And we need to find the right forum to handle those disputes. So I must say that arbitration could be a critical path for us, maybe sometime to avoid going to court, to maintain the information confidential, the nature of the dispute, to try to resolve amicably anything that could lead to damage our reputation. So to that extent, you know, for me, contributing to this panel and learning more is critical, because I exchange with outside counsel around the world on a regular basis to ask the question: should we go to court? Should we go to arbitration? What arbitration? And depending on that answer, well, we're happy, we sign the contract, everything goes well. But the day things go wrong, then in most cases, we're happy to sit in arbitration versus a court type of proceedings to resolve our concern or issues with partners or clients.
Well, thank you, Alex. Keely, Blair, you and your partners at Oric have completed a guide with a pragmatic overview of data protection and cyber laws across the jurisdictions of 16 different countries, and perhaps addressing some of the concerns that Alex has dealing in different jurisdictions. What must an organization do when a personal data breach occurs?
Well, thanks, Jonathan. It's a really great question. And, you know, obviously, when we talk about the 16 jurisdictions, that really is only the tip of the iceberg, actually, when we look at data protection laws across the world. I think presently there's about 132 different data protection laws in play at present. And everyone talks about the big ones like GDPR and CCPA, but people often forget about things like Brazil, Canada, the Philippines, Turkey. So many jurisdictions where we're starting to see privacy coming to the forefront of legal developments and also cybersecurity as well. But you asked the question regarding what do we do in the event of a personal data breach specifically. Obviously, things are harmonized in Europe. That makes things slightly easier in terms of knowing your notification obligations. But frankly, in the event that an organization does suffer a personal data breach, the key thing is really to get on top of what your regulatory notifications are, both in terms of individuals and in terms of wider data subjects, but also any contractual notification provisions that you have as well, which may be very important from an arbitration point of view, actually, because we find that oftentimes there are contractual notification provisions regarding data breaches where there may then be triggered arbitral mechanisms in order to deal with any fallout or any loss that occurs as a result of a data breach, vis-a-vis company to company. So I think that's very interesting. The other thing to note as well is that when we talk about cybersecurity and data protection, it's a relatively new and developing area of law in terms of arbitration. And there are a couple of kind of key areas to watch, I think. So the first is if we talk a little bit about Privacy Shield, which I think many of us will have heard of in terms of being struck down by the recent Schrems II decision. Privacy Shield used to have an arbitration mechanism as an option for solving disputes under Privacy Shield. It'll be very interesting to see if Privacy Shield's soon-to-be successor, which I'm sure will be hotly contested between Europe and the US, to see whether it also allows for an option to arbitrate as a way to resolve disputes. Another area that we're looking to see more and more arbitration in is frankly around data portability. So again, this is the right to use your data on different platforms. And again, this is a very key issue for organizations in terms of their obligations for cyber and privacy. There's one other area, but I'm not going to steal James's thunder because I know James is going to talk about it, which is around mass arbitrations in the event of data breach claims. And so, James, I'm happy to chime in after you've had your go, but I don't want to steal all the good stuff in relation to talking about the challenges surrounding mass consumer arbitrations and data breaches.
Can you give us a sense, Keely, of how your work is impacted by the lack of uniformity between, say, the European Union and the United States with respect to the data and cybersecurity laws and reporting requirements?
No, absolutely. And it means that international organizations have to be particularly au fait with both, right? We talk a lot about in Europe, there's harmonization. In the United States, there isn't. You have a number of state laws which will require different things to be done in the event of a data breach or a cybersecurity incident. So it does give an added layer of complexity because there is no overall federal statute in the states around data privacy and cybersecurity notifications in that sense. I think the other thing to bear in mind is we're talking simply about, when we talk about Europe and the US, there's a whole world out there of other complex laws that we need to think about. So there's data localization requirements in India and Russia that present particular challenges as well. And arbitration can be quite useful in terms of dealing with some of those.
Well, you mentioned your partner, James, who is an advocate at ORIC and also an arbitrator. James, you deal with a lot of disputes which are complex and involve a wide variety of confidentiality and sensitivity issues over multiple jurisdictions, and you have quite a bit of experience with IP and tech disputes. How is the international arbitration process dealing with mass and class claims and consumer arbitration issues?
Thanks, Jonathan. Thanks for mentioning me, Keely, and it's great to be here and to try and help. So one of the things that Keely was talking about was lack of uniformity. And one of the things that Alexandra wishes to avoid as a user of the arbitration system is lack of uniformity, lack of predictability. And arbitration can help, and we can talk about that a bit later. But a good example of one of the areas of lack of uniformity is an issue which is around right now, which is about consumer arbitration and mass consumer arbitration, class consumer arbitration almost. There's much been written about this in commentary and discussed over time, but what we are seeing now is a very great difference between the United States and Europe, notably. In Europe, the guidance from the European Union and national law in, for example, France and England is that a click and adhere to arbitration situation or consumer subscription arbitration situation, which will be relevant for many tech companies, gaming companies, for example, isn't enforceable in England or in Europe, basically, because the arbitration agreement is inappropriately brought to the attention of the subscriber clicker, and because it's an erosion of freedom of choice, etc., for reasons we would be accustomed to. Now, I'm not aware if any consumers have attempted to rely upon the clause anyway and say that they accept it and they rely upon it. But in any event, what you would end up with is bipartite arbitrations under whichever arbitration rules may be used. Now, you could theoretically end up with a number of arbitrations that might be consolidated, theoretically, particularly under the amendment to the ICC rules for 2021, where arbitrations could be consolidated under one or more arbitration agreements, plural. Okay, but we're not seeing mass claimant action in relation to consumer and data-driven arbitration in Europe for the reasons I've explained. However, meanwhile, across the pond in the United States, the opposite is happening and interesting things are happening. Notably, there is a prohibition. Well, no, it is most recently in the case involving Marriott Hotels, clear that consumer arbitration does bite and is applicable. These arbitration clauses are often paired with a no class action bar in the terms of the arbitration agreement. But because the arbitration agreements are valid, what you end up in is a situation with potentially an extremely large of consumers now being the target of funders or entities that would normally deal with class actions, bringing them together to arbitrate together in a coordinated fashion against a target company in relation to data and cyber breaches, for example, with an added cherry on top, which is in the United States, it is unlawful to require that a consumer pays the arbitration fee, the filing fee. And so what the claimants have twigged is that if they coordinate their mass arbitration action and consolidate those arbitrations, and there are thousands of individual arbitration actions, the fees have to be borne by the target company, the respondent, bringing a very significant financial burden, which is of itself likely to be sensitive to evolving US case law. So you effectively have mass consumer arbitration in the purview in the United States, which is the opposite of what's happening in Europe. Keely, does that roughly describe it, would you say?
Yes, it does, and it ends up with actually organisations facing the very unenviable position of facing a potential class action in Europe and in the UK and a potential mass arbitration in the US, which is the worst of both worlds, I think we can quite confidently say. And it's interesting because obviously the European Union is looking at different collective redress mechanisms, which will be outside of the arbitration regime. So it's a really interesting and new development that we're starting to see, and we're starting to see it being used in a weaponized way as well, aren't we, James, in terms of in practice by these claimant lawyers. And it's difficult because we're talking to our corporate clients who are drafting their arbitration agreements. And presently they have to deal with the complexities of having to draft one set of agreements that focus on the Europeans but don't require arbitration, one set that focuses on the Americans, which does allow for arbitration, and now they're trying to deal with this additional issue. So it's presenting further and further problems, and there's not a lot of case law on it yet, so we're not quite sure where we're going.
So is it the case that
maybe I can add in a few words here.
Please,
so,
Dan.
Yeah. So in terms of the mass class arbitrations in these kind of proceedings, the Netherlands is a very typical jurisdiction where you could, on the basis of the laws that James and Keely just referred to, even if there's an arbitration agreement, you can go to court as a consumer. But then if masses of consumers together lodge a class action before the court, you have the system that through those court proceedings, a case is being kicked out, sort of say, back into an ADR mechanism for the resolution of those mass claims, because the judiciary in the Netherlands then says, well, if you have hundreds of thousands of sort of similar claims, you are not going to backlog our system with that. We can address a settlement agreement here in the proceedings before our court, but then the case needs to, upon the resolution and the conclusion of a settlement agreement, the actual disputes between the parties needs to be settled through arbitration. So you have a couple of phases. You have one phase before the court, and basically a party says, yes, I am liable. I will put up a fund with a certain amount of money, but how that needs to be distributed and how much claimants have actually got a valid claim and have submitted that, that will then again be addressed in a ADR mechanism, and that can then be arbitration.
So the courts can compel arbitration?
Oh, in our mass claim legislation, it is necessary for any settlement agreement that is entered into that a mechanism is incorporated, an ADR mechanism for the resolution of the actual disputes between one party and, let's say, the liable party that has by then accepted liability. Yeah.
That sounds vastly more pragmatic than any of the other systems that I've heard of, that's for sure.
So James, how are consumer arbitrations, mass consumer arbitrations currently being handled in the European Union or in the UK?
Well, the mass pretty much as we've explained, it's an evolving topic right now, and as Keely mentioned, you know, entities with consumer exposure which have arbitration agreements of that type, of course, the only way you can, because you're not going to have bilaterally negotiated and signed arbitration agreements, are facing this issue, and it's absolutely going to evolve in the United States. In Europe, I confidently predict it won't enter into arbitration in any meaningful way at all. But it will evolve in the United States. And of course, the companies that are involved in it are doing global business, so it's not a localized problem. Global companies will have to face that problem in relation to their business model. I mean, yeah.
Thank you. Stan, let me ask you, arbitral institutions have stepped up their efforts regarding the security and privacy of consumer and case information. The AAA ICDR, for instance, has published its best practices guide for maintaining cybersecurity and privacy in arbitrations. Now, as both an advocate and an arbitrator in international cases, what are your experiences with the increased focus on security procedures in arbitration proceedings themselves?
Yeah. Well, it's a good point. I think it's very important for us to be aware of the importance thereof, and that we need to advocate towards the international arbitration community that this is a focus point for us all. My experience with, let's say, enhanced security measures is limited. I think you need to review this on a case-by-case basis, whereby especially the types of cases that Alexander and Keely were just referring to, those are very important cases whereby this needs to be addressed. What I typically do myself, if I sit as an arbitrator at the beginning of a case, I do ask parties to raise it, or I'm raising this with the parties to see if they consider this sufficiently important to do something additional with it. In the cases that I've seen, I have not yet seen a big significant shift towards applying indeed more security measures, but that may also have been due to, let's say, the lack of cases that Alexander is facing with on a daily basis. I think it is important for us, now that all kinds of protocols have been drafted to that effect, it is rather generally known that this is an issue in specific type of cases. We need to address it upfront at the beginning of an arbitration, I would say, rather than just before certain information is being exchanged, and together advocate that this is an issue. It will become an even bigger issue as time passes, I would say. We need to be aware of it at this time, and in appropriate cases, act on that. But I'm very interested to learn, for example, how others have then in fact implemented certain measures in their arbitration where this was an issue.
Alex, could you comment on how SICPA deals with the exchange of information and its disputes, maintaining the security of that information?
I'll try. really it's almost every setup. I mean, we have different type of businesses. So every business, we have to look at where the data flows, what kind of data is flowing, looking at, you know, what Kiri was saying about, oh, the data is going from what, Switzerland to this country or this country, and figuring out what the rules are between a GDPR or another privacy rule in different countries, which one is more stringent, which one requires that the data remains within the country if we need a local server. So it's a mix of those data protection laws and the cybersecurity system that we need to put in place. So one typical example would be to say that, oh, it's going to be in the cloud. Okay, great, but it's a cloud, but there is still a server. Where does the server sits? In Europe, in the US? So who's going to be able to access that information? And so you're more or less exposed depending on the country, but it means that we're working with our data privacy officer in every instance, who's somebody who understands very well the world of data and will help us map out those data, the quality of data, where they go, and so on. And then depending on that, we'll look at the regulation to see if we're a processor, a controller, or whatnot, what rules we have. We'll have discussion with our customers, partners, to make sure that we are on the same line and same understanding of what needs to take place as far as who's responsible for what between them and us. And most often it's us just operating a system with their data. And I would say that other than looking at this regulatory environment, putting contractual provisions, as we said earlier, and now, for example, with the US changing, it's more in your contractual clauses that, than the privacy shield you're going to rely on and so on. But so down the road, it's all this regulatory environment, but there are two things we can do is one, how our technology avoids for personal data to flow to us. So there are some of the technology we're developing where we make sure the data remains with the user, the partner, or customers and doesn't come to us. So we don't even carry any responsibilities as far as personal data. So trying to avoid that. When we cannot do that, and maybe we're either using our system or using a third-party system, the encryption keys, for example, would be quite critical to avoid any authorities trying to seize information or access information and trying to add a layer on top of regulation, contractual obligations, and then the cybersecurity as far as real security. So that would be, yes, the physical security of the sites, but also those encryption keys that today's, whenever they work, they are truly the ultimate tool for us to be able to control what information we grant access to third parties.
Alexandra, can I just jump in there? I think you made a really great point, and the same as Stan. And actually, there's such an onus on people like us who work in this field to help to educate our clients on this, because actually a lot of our clients don't understand the questions they should be asking around security and around data protection issues and what steps they need to take in place, even if they don't even understand that the encryption technology is available to maintain data security. So helping them and equipping them with that knowledge and helping them to understand that there are ways in which arbitration can assist that it can be put into the procedural orders, that there are ways in which it can be baked in. I think it's so incumbent on us all, right, to educate ourselves and then educate our clients on the back end of it. But it's, as you said, technology is the best solution, right? It's better than relying on a human, that's for sure.
Yeah, so and on the education front, it's, for us, in-house counsel is, trying to be educated by the outside counsel, because there is no way we know it all. Working in a very international environment, we really need the support of outside counsel with the local expertise, comparing to what we know that is more familiar in Europe, and then educating the partner as well, because there is also difference of interpretation as to what really applies. So a lot of time you go in those discussions that, well, are maybe going nowhere. So for us, very critical to have that discussion with the partners, but it means that we need to educate ourselves to make sure we master enough of the concept to explain it to the partner, and then move on to putting the right clauses together. But then we come back to the choice of arbitration versus courts. So it's also, again, discussing with the outside counsel to say, hey, we're having this discussion, here is the setup, the kind of data protection issues we may have, the kind of cybersecurity we're putting together. Do you think we will be well protected if we go to court on a dispute over that? Arbitration, which arbitration? And do you think those type of arbitration forum offers the right expertise to make sure that they can deal with something that deals with two international companies that are on a different level?
Mhm. James, perhaps you could comment on how arbitration deals with data and cyber issues in cross-border and multi-jurisdictional disputes.
Yeah, well, thank you. And it follows on from what those who've just been speaking have been talking about. I'm not an evangelist for arbitration in the sense that I always say it's God's gift to everything that people should want in a dispute resolution forum, and there are times you might want to be in court. But I think that data and cyber is a particularly good example of some of the merits of arbitration and what it can do to bring a measure of uniformity and security in every sense to users like Alex. It goes to the heart of what arbitration has to deal with. I mean, first of all, it is by its nature international arbitration, multi-jurisdictional. That's what we're talking about. So the challenge that it faces is how to deal with the variety of international laws concerning data use and their application and their different applications, be they localization laws or whatever it might be. And we can talk about some of the countries that are involved. The second challenge is just the nature of the system, because if you really think about it, it's really quite frightening how many jurisdictions, laws, entities, and people are involved in the absorption and transfer of data, i.e. processing and controlling in the connection with an arbitration. You've got the arbitral institution in one country. You may have your arbitrators in 3 different countries. You will have counsel perhaps in a couple more countries. You may have an e-discovery provider in another country. You may have your translators and interpreters in another country. You may have your third-party funder in another country. And the list goes on and on and on. There's a very nice table that was produced by another law firm that will remain nameless. And it listed about 80 participants that could be involved in processing and controlling. And that means all of these different laws will apply to these different people, and it'll then infect and be involved in various different parts of the arbitral process. Disclosure is an obvious one, and harvesting data and providing it to your e-disclosure provider, or reading it and considering it, or providing it to your arbitral tribunal or the opposition is going to cross national territories. If you are dealing with GDPR, one of the interesting points is there are various legal proceeding type exceptions to it. So GDPR doesn't necessarily provide you with such an absolute impediment and difficulty. There are also authorized other states, and there are several relevance and proportionality and legal use exemptions from the non-transfer of data under GDPR. But other countries like Russia or China will cause significant problems because you're not allowed to export data. There are arbitration practitioners dealing with Russian-related disputes, harvesting disclosure and data information every single day who aren't thinking about this at all. And there are defendants who will take advantage of opposition to providing documents if they know what they're doing. So clients need informed counsel at every angle, and moreover an informed tribunal in order to understand the interconnection between these laws. You've got issues about data privacy in awards. You've got issues about data privacy in relation to the conduct of an arbitration and the security measures that relate to its being run. And you've got issues of data privacy about data issues in relation to destruction and maintaining records after the arbitration. And the point is that all of these, arbitration has a lot to do and to help in relation to these interconnected issues. And I do honestly believe is ahead of the game. And there are some terrific documents, notably ICA, both in relation to collaborating with other entities, both in relation to cybersecurity measures for arbitration, and also in relation to its recent working paper in relation to arbitration, international and data and cyber issues generally are well worth reading. But it comes down to knowledge. And I think one of the most important issues and thoughts for a user like Alex is that it's a tribunal-driven environment. In arbitration, if you're in this sort of arbitration, it's extremely important and of great benefit to be able to choose a tribunal who understands these issues. And it is extremely helpful in the arbitration process that they can, if they're informed, deal with these things early, have a data protocol, consider mapping the different data laws, deal with objections and potential issues early. So, for example, if you're dealing with Indian issues, this is a consent-driven data environment, you deal with it to avoid potentially guerrilla tactics in your arbitration later when suddenly at the disclosure phase, somebody says they can't provide any of the information that's caught in the dispute. If the arbitration is well run with a strong tribunal, they will look at these issues early, analyze them and make sure that they can try and be in a situation where this won't be dealt with. And I think this comes all the way, and I'd be interested in Maxi's view on that, and to the extent tribunals are dealing with these issues early, as often as they ought to be. And I think this comes full circle in the end to what users will look for, which is rightly done. Arbitration can take great benefit from its inherent confidentiality, its flexibility and its expert decision makers to provide predictability, which you don't get if you may end up in some national court somewhere. Because it's all fine talking about how the protections in California in the English court might be, but if you're in, fill in the name of the country, local court, this is not where a user wants its information to go and stay there for the next X amount of time and give it all sorts of different exposures. So arbitration's moving well. There's a good deal of focus on it, but significant challenges, but I think it's well placed in this environment.
So James, you were just referring that you were interested in hearing from Maxi as to how tribunals perceive this. You could also spin it around a little bit and take it back to the position that if you're acting as counsel, you're sort of in the lead and able to drive certain issues that you think are of importance to the tribunal, of course. So there's a bit of a interplay, I would say, between counsel and tribunals on the one hand, because there will be tribunal members who are not sufficiently well versed in the matter as well, and they need to be potentially educated as well by you.
I'd be interested. I mean, Maxi is dealing with so many large arbitrations, but everybody's, of course.
We do have a question I'd like to put to you all, starting with Stan. The question is to follow up on Stan's point on cybersecurity and arbitrations. We would all agree that cybersecurity is a critical consideration in the business world, including in law and arbitration. But I wonder if our current focus on technical cybersecurity and arbitration procedures is largely a creature of our own creation. Even in major cybersecurity cases, I rarely see counsel particularly concerned about cybersecurity details. They are rarely prepared or addressed in discussing it. Is your experience different? Specifically, do any of you have detailed cybersecurity provisions in your arbitration orders?
Oh, this is a very interesting question, but my experience is actually rather the same as Gary's experience is. The parties are sometimes not even interested in this issue at all. They want to get the case pending without taking too much consideration of these kind of matters. That's my experience, but I think it's all for us that we need to educate the clients, counsel, everybody in the field that this may be an issue, because you only have to face one big data breach in such a case and you will have a catastrophe. Yeah, but my experience is rather similar as Gary's.
If I may add, I think that's absolutely right. And I think there are actually two situations sitting as arbitrator that you see. Either you propose a very detailed data protocol at the outset, and that sometimes get you frowning eyebrows from parties thinking that you spend too much time and costs on these detailed provisions, and there's no need to do about that. Or you sit with arbitrators and there's quite a bit of a knowledge gap in terms of what are we supposed to do, etc. It's noteworthy that the LCIA rules in their latest 2020 revision have actually included a specific provision on data protection. I think they're one of the first sort of major international rules to put this up front and include not an obligation, but an encouragement to the arbitral tribunal to discuss these points at early stages of the arbitration. It's Article 30A for those who are interested and can have a read of this particular provision.
Maxi, I think you make a great point there, though, which is everybody sees the world through their own lens, right? So I'm a cybersecurity and privacy lawyer, so I see these issues everywhere. I equally would not have a clue if I was looking at the ins and outs of an oil and gas deal, right? That's not my bag. That's not what I know. I think that's often the case. It's the knowledge gap, actually, because we are hiring arbitral panels and counsel that are experts in the field that's being arbitrated. They're not experts in cybersecurity and privacy, so they might not see unknown unknowns, right, that we're expecting people to deal with. And so there's that difficulty in terms of education.
2 points on that, Gillian, you're absolutely right. I was involved in a discussion on a revision of quite well-known international arbitration rules, which I'm not going to name where they are, where there was a discussion as to whether it was required to include provisions on data protection, and the sense was, why would we? So that's one point. And the other point is, I've never seen it myself in an arbitration, but I have heard, and I think it's certainly something that we should consider, that arbitral tribunal, just as they might appoint an administrative secretary to the tribunal, or in the current circumstances of virtual hearings and remote hearings, a sort of a technology manager, that they also might, in certain instances, appoint a secretary or help of someone who is versed in data protection, if that is so needed. As I said, I've never been involved in a case where that has happened or was required, but maybe this is something that is worth considering as well.
You know, I'd like to ask Maxi, in your practice in dealing with cybersecurity and data matters, and you're sitting as arbitrator, do you attempt to deal with the universe of those issues as brought to you by the party in an early procedural order or terms of reference, or do you let the process go a little bit and check on it on an iterative basis?
I think it depends. I certainly have cases, some of the pharmaceutical cases I'm involved in, where I'm mindful that there is a lot of client and personal data involved, where, for instance, the privacy security issues are very important. Others where maybe it's less so. I would certainly at least ask the questions to the parties, but let me just give you a little bit of flavor in what world we're operating under. I still see co-arbitrators using Gmail email addresses for their communications. That's the type of protection and level that we're talking about. I should also add that not so long ago, I was sitting with someone who didn't use email at all. And I had to basically have someone call the secretary to inform the co-arbitrator of the information of the email. So this is just a world of technology savviness, in quotation marks, that we're talking about in some of the arbitrators. So, if we say knowledge gap, that's probably an understatement.
Well, the ICDR best practices encourage these issues to be raised at the preliminary hearing and in drafting the initial procedural order. So I think it is an arbitrator's responsibility to make sure that adequate security measures are in place.
Also not using a Gmail account, perhaps. That is not the wisest idea. But to add on Maxi's comment in that respect, you don't also only see that by certain tribunal members. If you are in a particular case whereby group structures are across the BVIs, the Seychelles, whatever, and what have you, you often see nondescript email addresses where your party representatives also just always email from. So it's a point of caution for tribunals, but also for counsel, I would say, to have a email address working which is sufficiently safe.
But also in terms of what's not done, I don't think that anywhere near enough consideration about redacting or protecting personal data in relation to disclosure happens. I don't know what the other panelists' experience are, but people tend to get involved in the cut and thrust of the case, particularly the larger the disclosure exercise. And that type of redaction isn't commonly considered at all, in my experience.
Oh, so
I think it's
you
really
always
interesting, James.
basically...
Sorry, go ahead, Sam.
So you always would need to have a team in place where persons such as James and Keely are jointly working on a matter, so that also those concerns are always addressed appropriately and sufficiently in time. And that's maybe just one of the lessons.
I think the only time it ever comes up is when people are trying to use it as a weapon, right? That's the only time you see it, is when people are using it as a shield to try and prevent giving information. You rarely see people reflect upon the information that they are giving and think, is the information that I'm willing to hand over, have I actually really given it the necessary consideration from a privacy lens before I hand it over? And certainly if it's being handed over to a Gmail account, which made me visibly wince, I think, as you all saw, then I think it's of even greater concern, right? That information is out into the wild, so to speak, with very little encryption or protection around it at all. You can imagine, certainly, if any individual were ever to find out about that, there would be some issues.
Yeah, well, there's a cost and complexity challenge there, isn't there, I think, in relation to whether it's necessary to have, a bit like why would we bother doing it with the amendment of the institutional rules. In relation to challenges, yes, although reflecting on that, in relation to challenges in relation concerning disclosure, in the end, I think it approximates to a strong tribunal understanding of the law, because it's a bit like, confidentiality and sensitivity objections under the IBA rules, etc. There is law applying to it, and the tribunal should understand it, but it does come back to informed decision makers, of course, the importance of them in the process.
Stan, I'd like to ask you about the use of virtual technologies in arbitrations in Europe. In your experience, has that become the standard practice now? Have people warmed to having virtual remote arbitration hearings?
Well, I think for us all, we had to adopt for the Western European part as from the latter part of March of this year. And I think the international arbitration community has shifted towards virtual hearings quite quickly. I've seen a tendency in Western Europe as from June to September, I guess, where the restrictions became less, that Europe was reopening again, that it was possible again to get into a hearing room with persons rather than doing everything completely virtual. So I think as long as there's not a vaccine yet, that we see sort of a moving target whereby most global international arbitration cases will remain fully virtual because of all the travel restrictions. But I've seen a couple of arbitrations being conducted in the period of June through September that were conducted in Western Europe, just in person because it was possible again. The only caution was that a hearing room needed to be arranged for that was significantly larger than otherwise. But I think you'll see a trend, and due to cost efficiencies and what have you, probably we see a continuing effect also after the pandemic is passed away. But I see a trend whereby decision makers and also parties would prefer, if circumstances allow it, to get back into a in-person hearing room. Yeah.
Let me ask Maxi, do you think that virtual remote hearings in international arbitration are here to stay in the post-pandemic world?
Well, let's hope that's going to be a quick shift to the post-pandemic world. But I think, like Stan, I think it's a bit of a mixed picture. First of all, I think we should all remind ourselves that the remote hearings aren't necessarily something new that was invented during the pandemic. I've had a case about 10 years ago where we had a part of the hearing that was done remotely by video conferencing, and by that time, the video conferencing tools were certainly not as advanced as they are today. And ICSID, for instance, publishes its statistics, and in 2019, pre-pandemic, a majority of the hearings had a remote component. What is new, however, during the pandemic is first that it has become the norm because of the travel restrictions and other measures, and two, it is what I call these super fully fledged remote hearings, where every single participant connects from an individual screen, sometimes from their home offices, like we do now for this webinar. And I think that is new, and that is specific to the pandemic. There's no need to do that going forward. However, there's certainly new ways of combining videos and gathering that I have seen. For instance, in between the first and second wave in Europe, I had a couple of hearings in September, October, and some of them at least were done in a way where the tribunal would gather in one place. I was at the ICC with the co-arbitrators. Counsel for claimant was together in one room connecting remotely. Respondent was together in one room connecting remotely, and experts and witnesses as well. So it's not the fully super remote hearing that was necessary during the height of the pandemic, and hopefully not again during the second wave. But still, there is a very important video part. There is no one hearing room where people gather, and it is that type of remote hearings or hybrid hearings, if you want to call them that way, that I think will remain in our toolbox for the future. It's not necessarily for every single case that they are adapted. I've certainly also seen cases where the tribunal decided that it was better off to wait for an in-person hearing. But it is going to be a tool that stays with us. And maybe I can just mention, because we've all had experiences in the coming weeks and months, and even maybe before the pandemic, but they're still quite anecdotal. There is one empirical analysis that has been done, and the results have already been published. It's actually a chapter of a book that I've published recently, and so if you're interested, there is a lot of data in there on the feedback of users, arbitrators, counsel on these types of remote hearings. Lots of different data that I wouldn't be able to summarize now, but my main takeaway, and that I find interesting, is that the respondees of that survey have said in almost 60% of the cases that remote hearings are as good as or even better than in-person hearings. So 59% said so. And I think that shows that they will remain in the toolbox for years to come.
Were that the decision makers, Maxi, who also advocated in favor of virtual hearings to stay, or did that feedback came more from the parties?
I think that particular figure, if I remember correctly, was a mixture of different, of all the respondees. I think there were about more than 200 people that responded to the survey, and that included arbitrators and counsel. But I think your question goes to the fact that there is at least a perception that arbitrators love remote hearings because they don't have to travel, and that counsel don't like remote hearings so much because they feel that they're, maybe cross-examination through video is not as effective. And I'm not sure that is necessarily 100% correct. However, in that particular survey, there also the distinction, not only do you like remote hearings, but what did you think was most effective? I think some of the questions that were more dealing with expert evidence said that remote hearings might not have been as effective. But I think quite strikingly, the most positive for remote hearings was the understanding of the tribunal of the case. Did the tribunal get a good understanding of the case eventually? And here, respondees came out very strongly in favor of remote hearings. And at the end of the day, that's the most important, that your tribunal gets a good understanding of your case. I've certainly had remote hearings where we even had expert conferencing, so experts being examined together, and it worked, I thought, pretty well.
Well, Maxi, I have to ask you, because of your work in artificial intelligence, sorry. What are your views about the role of artificial intelligence in the future in international arbitration? Are there ways in which AI can improve the process, in your view?
Well, I'm quite mindful of time. I think that could be, I could go on for hours on this one, so I'll keep it short.
Well, we are running short on time. I wanted to ask you that question quickly.
So let me maybe give you a little bit of a bullet list on things that I think might be affected. I mean, e-discovery is certainly something where we already see a lot of tools proposed that use artificial intelligence. Selection of arbitrators is actually also one. My colleague from the university, Catherine Rogers, has this wonderful project, Arbitrator Intelligence, that basically profiles arbitrators using technology and artificial intelligence. What I will also say is that I think in the future, we don't, as far as I know, that doesn't exist yet, but we will certainly have tools that help us putting together, for instance, a chronology of undisputed facts or a procedural history. There's no reason why we would need to ask any junior lawyers to draft these documents in the future. Now, again, thinking ahead, I think we already have quite good legal analytical tools that predict the outcome of decisions accurately to a certain extent. There are important limitations to that. First of all, the data is always as good. The algorithm is always as good as the data. So if the data is somehow infected by, for instance, in investor state arbitration, a perceived or real bias in favor of the states or investors, you will have that infiltrated into the algorithm. And then in commercial arbitration, it's of course the access to the data itself, being most awards being confidential. I don't see that the decision makers will be replaced quite yet, because what the algorithm cannot produce yet is legal reasoning that is understood by the recipient of the award, i.e. by humans. So there is this issue of black box, that you get the right result, but you don't quite know how to get there. And what we need in an award, in a decision, is an clear path and a clear legal reasoning why you get there. However, you could say that predicting the correct outcome will prevent disputes from happening. If you get a prediction that you have an 80% chance of losing, maybe you don't want to start proceedings to start with. They certainly can help also in settlement discussions. They're already used by third-party funders to assess whether or not a dispute is good enough to be funded from their perspective. So here are a couple of sort of bullet points very briefly on where AI and technology might play a role in the future, and already does.
It's all very interesting. And of course, it raises the question of big data and the security of that data, who controls it, who has access to it. But certainly technology is moving, and hopefully it's gonna help us.
It's really interesting too, though, because there's a lot of challenges around Article 22 of the GDPR if it has a legally binding or similarly legally binding decision impact with AI. That's what Maxi was referring to about the issue with black box. You've got to be able to explain how you reach the decision, and that will be a challenge. And certainly, if that decision has any impact on individuals, you can imagine it being very, very hotly challenged. So people, I think, will be very careful, I imagine, Maxi, before using some of those. I'll be very interested to see if those arbitrators have consented to having the decisions profiled in that way as well.
Oh, interesting. Well, we're really down to our last minute here, and I want to thank all of the panelists for their participation today, and thank you all who signed in to be a part of our audience and have the benefit of hearing from these esteemed colleagues. I wish everyone a good evening, still a good morning on the West Coast, and a good afternoon here in the East. Nice being with you all. Thank you so much.
Thank you.
Thanks a lot.
Thanks,
Thanks, everyone.
Bye.